Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss a new ruling from the U.S. Supreme Court where we will focus on the dissenting opinion. The ruling we are discussing today is the Supreme Court's July 14th, 2025 ruling in a case called Linda McMahon, Secretary of Education et al. Versus New York. The case involves another unconstitutional executive order issued by President Trump, this time Executive Order number 14242, titled Improving Education Outcomes by Empowering Parents, States, and Communities, that was issued on March 20th, 2025. The executive order, in short, directs the closing of the U.S. Department of Education, which is an executive branch agency. However, the agency is a product of congressional statute. The only way to lawfully terminate the agency is via a new congressional statute. An executive order cannot nullify the existing statute creating the Department of Education and its mandate, because Congress passes laws and presidents are supposed to enforce laws passed by Congress. Presidents do not have lawmaking authority under the U.S. Constitution. Yet, President Trump issued his executive order, and now the majority of the Supreme Court just paved the way to permit President Trump to carry out execution of the executive order, while the substance of the case is litigated through the lower appellate court and potentially the U.S. Supreme Court until a final ruling on the substantive legality of the order is ruled upon. Basically, the Trump administration can proceed until a final court order rules that the executive order is unconstitutional, despite the plain illegality of the order, because executive orders are not law and cannot supersede law. The majority opinion, which does not provide the author's name, provides no reasoning for placing a stay on the injunctions that were in place from the lower courts. The majority opinion, which is only a paragraph long, states, quote, "The application for stay presented to Justice Jackson and by her referred to the court is granted. The May 22nd, 2025 preliminary injunction entered by the United States District Court for the District of Massachusetts is stayed pending the disposition of the appeal in the United States Court of Appeals for the First Circuit and disposition of a petition for a writ of certiorari, if such writ is timely sought." I will next quote from the dissenting opinion that was authored by Justice Sotomayor, which states in part, quote, "This case arises out of the President's unilateral efforts to eliminate a cabinet-level agency established by Congress nearly half a century ago, the Department of Education. Only Congress has the power to abolish the department, yet by executive fiat, the President ordered the Secretary of Education to, quote, "take all necessary steps to facilitate the closure of the department." Consistent with that executive order, Secretary Linda McMahon gutted the department's workforce, firing over 50% of its staff overnight. When the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. Two lower courts rose to the occasion, preliminarily enjoining the mass firings while the litigation remains ongoing. Rather than maintain the status quo, however, this court now intervenes, lifting the injunction and permitting the government to proceed with dismantling the department. That decision is indefensible. It hands the executive the power to reveal statutes by firing all those necessary to carry them out. The majority is either willfully blind to the implications of its ruling or naive, but either way, the threat to our Constitution's separation of powers is grave. Unable to join in the misuse of our emergency docket, I respectfully dissent. Until now, presidents have recognized they lack the unilateral authority to eradicate a department that Congress has tasked with fulfilling statutory duties. Undeterred by these limits on executive authority, President Trump has made clear that he intends to close the department without Congress's involvement. The founders of this nation entrusted the lawmaking powers to the Congress alone, and there is no provision in the Constitution that authorizes the president to enact, to amend, or to repeal statutes. The president thus lacks unilateral authority to close a cabinet-level agency. Congress created the department, and only Congress can abolish it. The president, too, may not refuse to carry out statutorily mandated functions as assigned to the department, for he must, quote, take care that the laws be faithfully executed. The record evidence credited by the district court and unrebutted by the government thus leads to one conclusion. The executive has seized for itself the power to repeal federal law by way of mass terminations in direct contravention of the Take Care Clause and our Constitution's separation of powers. Before this court, the government does not defend the lawfulness of its actions. Rather, in a now similar move, it presents a grab bag of jurisdictional and remedial arguments to support its bid for emergency relief. The president must take care that the laws are faithfully executed, not set out to dismantle them. That basic rule undergirds our Constitution's separation of powers. Yet today, the majority rewards clear defiance of that core principle with emergency relief. Because I cannot condone such abuse of our equitable authority, I respectfully dissent. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.